Hey everybody, Zach Wolf here with another great Top 5 Tuesday. I just got done making a presentation to the Houston Bar Association Labor and Employment section about non-competes. So I thought this would be a good time to recap some of the points I made, and I'm starting with my 5 obvious tips for handling non-compete cases. Are you ready? Here we go. So tip number 1 is that you need to make the scope of the non-compete reasonable. It needs to be reasonable in time, reasonable in geographic area, and reasonable in scope of activity. So if you're drafting a non-compete, make sure you take care of those 3 things. The one that people mess up the most often is the scope of activity. Don't make it an industry-wide exclusion. That's too broad under Texas law. It needs to be limited to the customers the employee actually had dealings with. Also, make sure you plan your exit from the hotel appropriately, because you may not be able to get down the stairs. So let's try over here. The number 4 obvious tip for handling a non-compete case is that if you're handling a non-compete lawsuit and you're going to try to get a TRO or a temporary injunction, you want to have evidence that the employee's customers or some of the customers have already left and followed the employee. If you don't have evidence like that, you may have a hard time persuading a judge that there's some imminent harm that has to be prevented with a TRO or a temporary injunction. The number 3 obvious tip for handling a non-compete case is that if you're going to go get a TRO or temporary injunction, you want to read the rules. If you're in state court, you want to read rules 680 and 683. If you're in federal court, you want to read rule 65B. Make sure you understand the requirements in the rules for getting a TRO. All right, we're leaving the Magnolia Hotel now, and it brings me to the number 2 somewhat obvious tip for handling a non-compete case, and that is that you need to consider, if you're representing the plaintiff in the case, consider whether the employee's new employer is a necessary party to the lawsuit. In case you didn't hear that, consider whether the second employer is a necessary party. There is some Texas case law that says if you're asking for an injunction to prevent an employee from competing, that the employee's new employer is a necessary party to the lawsuit. All right, that brings me to the number 1 obvious tip for handling a non-compete case. If you're trying to get an injunction, you need to have some evidence of irreparable injury. Now, some people will make the argument that the Texas non-compete statute doesn't require irreparable injury, but Texas courts, at least some of them, have said that the common law requirement of irreparable injury still applies to a non-compete. And also, you may get people arguing that the stipulation in the non-compete can satisfy the irreparable injury requirement. I'm talking about the kind of stipulation where it says that employee agrees that a violation of the non-compete would cause irreparable harm for which an injunction may be granted. You can put that in your non-compete, it doesn't hurt, but don't expect judges to accept that alone as satisfying the irreparable injury requirement. So those are my 5 obvious tips for handling a Texas non-compete case. Did I miss one? Is there another obvious tip you'd like to point out? Hey, let me know. And thanks for watching.